This is Bentley Tolk with another video from the ERISA Litigation channel. I'm a lawyer at Parr, and Loveless in Salt Lake City, Utah, and this channel will help you to keep current on the latest ERISA cases and to hear some analysis of new ERISA cases. Today we're going to talk briefly about ERISA standing and complete preemption under ERISA, particularly with regard to a new 10th Circuit case. In that case is the Hansen v. Harper Excavating case. It's 2011 U.S. App Lexus 7553. Again, it's a 10th Circuit case from April 3rd, 2011. Well, in this case, the plaintiff thought that he was properly enrolled in his employer's group health plan. However, he wasn't properly enrolled, despite his efforts to do so. Now, despite the fact that he wasn't properly enrolled, the employer was still deducting plan payments from his paycheck. After the plaintiff left the company, he became sick and discovered that he didn't have health coverage. Well, what happened was that the plaintiff ended up bringing an ERISA case in federal district court and was awarded medical expenses as well as attorney's fees. Now, during discovery, during the process of that ERISA federal case, the plaintiff discovered some other causes of action that he thought he had. And so what happened was that the plaintiff later filed a state court action for related state causes of action. The former employer removed state court action to federal court and then asked the court to dismiss the case. When the plaintiff objected to removal, the federal court treated that objection as a motion to remand. The federal district court dismissed the state law claims and denied the requested remand to state court. In the 10th Circuit reversed the district court. The 10th Circuit concluded that the plaintiff's claims were not completely preempted by ERISA and that plaintiff's state law claims should be remanded to state court. Now, with regard to standing, what the 10th Circuit said is that ERISA standing is assessed as of the time that the complaint is filed. And the court had an analysis of but-for ERISA standing and contrasted it with some of the other circuits and said that in the 10th Circuit confirmed that there is no standing, no but-for standing in the 10th Circuit, and that you can't have standing due to the fact that but for the employer's actions, the plaintiff would have been a participant in the ERISA plan. So the plaintiff would not have had standing under ERISA here. Because the plaintiff would not have had standing to bring his claim under ERISA, the court concluded that there was no preemption, no complete preemption. Now, the plaintiff wasn't a participant in the former employer's plan at the time he filed his complaint because he didn't fall into one of the four Firestone categories as enumerated by the Supreme Court. First of all, he wasn't an employee currently in covered employment. He wasn't an employee reasonably expected to be in covered employment. Thirdly, he wasn't a former employee with a reasonable expectation of returning to covered employment. And then fourth, he wasn't a former employee with a colorable claim to vested benefits, meaning a former employee with a colorable claim that either he would prevail in a suit for benefits or his eligibility requirements would be fulfilled in the future. So the plaintiff had no colorable claim. Really, it was only the fourth category that could have applied, and the plaintiff had no colorable claim that he would prevail in a suit for benefits because he had already prevailed in his earlier ERISA suit for benefits. The plaintiff also had no colorable claim that his eligibility requirements would be fulfilled in the future. Thus, the plaintiff had no standing under ERISA, and his claim could not be completely preempted. So this Hansen case, I think, especially for those in the 10th Circuit, but also it's a good review of but-for standing under ERISA, and it's a good opportunity to look at some of the issues of complete preemption. For Bentley Tolk at the ERISA Litigation channel, until next time, thank you very much.